Additional witnesses, people rest.
All right. Any witnesses for the defense?
No, Your Honor.
All right. Do you have a motion?
Yes, Your Honor. At this time, people move for bind over on the single count of assaulting, resisting, or obstructing Darnell Tyson. Will reserve any further argument for rebuttal.
Respond. The sergeant's name was Sergeant Griggs, wasn't it?
Gibbs, G-I-B-B, both as in boy, S.
Why are we not hearing the testimony of the other witnesses?
I'm sorry?
I was asking why we're not hearing the testimony of the other witnesses.
Because neither one of the parties called them.
I would like to call them, Your Honor.
This courtroom moment starts like a routine procedural exchange, but within minutes, it turns into a tense legal tug-of-war over witness procedure, evidence integrity, and courtroom control. You're about to see a defendant push aggressively for additional testimony after the prosecution rests, and the judge's patience gets tested more than once. Watch closely how the rules of witness sequestration, objections, and legal form collide in real time. One small procedural mistake, letting officers watch testimony online, suddenly becomes a major credibility issue. The question is, does reopening testimony help the defense or backfire badly? Stay with this because what happens next shows exactly how fast courtroom strategy can flip under pressure. And I want to know, would you reopen witnesses if their testimony might be compromised?
Any objection to reopening the proofs?
I will let the court know part of the reason I changed my mind is because I failed to instruct the officers who were in the hallway that they could not watch the proceedings on YouTube. So it's my understanding they did watch the testimony of Officer Tyson on YouTube, and I apologize for that. Didn't intend to have that happen. I deeply am regretful of that. I did not know what was going on until I went out in the hallway. Didn't intend to call them because their sequestration had been broken and rest on the proofs that were proved for the court.
Still wish to call them?
Yeah.
Yes?
Yes, I do, Your Honor.
Are they still here?
I believe so. Which one?
Which one do you want, sir?
Both of them.
Both of them. Great. Just bring everybody back.
All right. Sounds great.
The prosecution rests and moves to bind the case over, but the defendant pushes to reopen witnesses. From a third-party perspective, this is a risky strategic move. Reopening testimony can expose weaknesses, but it can also spotlight procedural cracks. Here, the issue of officers watching testimony online. The judge allows it, but you can already feel the tension building as courtroom order becomes the real battleground. Now the tug-of-war intensifies.
Okay. So, which one do you want to call, Mr. Magoo?
Start with Officer Smith.
All right. Officer Smith, did you want the other officer? Did you want the sergeant? Did you want the sergeant sequestered during this testimony, or
Yes. No, you do.
no? You don't give orders. You just don't.
Sorry.
You just don't. No, you don't.
It was a request.
No, it doesn't matter. Yeah, keep smiling. That won't end well. Let's have him talk.
Raise your right hand. You solemnly swear to affirm the testimony about to give the truth, the whole truth, and nothing but the truth. See, state your first and last name for the record, please.
First name is Lawrence, LAWRENCE. Last name is Smith, SMIC.
You may inquire.
Oh, they don't start at all. Is it on?
It's your witness.
Right. How you doing? Um, you'll have to lay a foundation with, since we all know where we're at on the night. Where were you in the October 11th, 2:50 in the morning, and what brought you to there?
Objection compound.
Okay.
Sustained. Ask your question.
What led you to a parking lot in Ypsilanti on October 11th, 2024 at 2:50 in the morning, approximately?
We were dismissed to a
Fight in progress.
Yes.
Did you get a description of the people in the fight? What was the description?
As questioning begins, objections fly and the judge repeatedly reins the exchange back to proper legal form. This hearing unfolds in a Michigan courtroom, operating under rules shaped by the Michigan Supreme Court, and you can see those rules in action. To an observer, the defense is trying to challenge probable cause and officer authority, but struggles with framing questions that call for facts instead of legal conclusions. The judge's interruptions aren't personal, they're structural guardrails that keep testimony admissible and focused.
Do you remember? You were just looking for 2 people, or how many people? Don't recall. Okay. Do you recall the ethnicity of the people that were called? Were they what the dispatch? Who was the dispatched over the fight? I believe they gave some descriptive words in the police report. And do you recall what the do you recall any descriptive words that would characterize the people that you were looking for on October 11th? What led you to approach me?
Well, we've seen an individual sitting, obviously slumped over and looking unresponsive at the point, and we've seen alcoholic beverages around the individual, so we assumed it was high head touch. So at that point, it's our job and duty to end up rendering aid to the individual, and then having the ambulance come and assess their medical needs at that point.
Okay. You assessed that another individual was highly intoxicated?
Yes, due to our observations and our working backstory.
Is that a crime? Highly intoxicated?
Objection, Your Honor.
Sustained.
Which part of assuming somebody was highly intoxicated warrants your interjection?
Can you ask your question again, just for clarification?
Are you trained on high intox?
I'm not trained in high intox.
On recognizing drunk drivers or something?
The discussion shifts to reports, alcohol evidence, and evidence handling protocol. From a neutral lens, this is less about winning an argument and more about building a clean record. Every sustained objection narrows the scope, forcing the defense to adapt in real time. The takeaway is sharp. Courtroom success depends on precision, relevance, and rule compliance, not volume or persistence. Like the video, drop your verdict in the comments, and subscribe for more real courtroom breakdowns that reveal how the justice system actually works.
I've been in the police for less than a year, and I've observed multiple people that have high intox, and then also got directed from my sergeant, who's also been doing this for 4 years plus. I believe that we can observe somebody that's high intox. So that
He was definitely highly intox, huh? You would guarantee, right?
Your Honor, that misstates the testimony evidence.
You can keep trying.
Okay.
The form of your questions are a problem.
Okay. At what point did you and I engage physically?
When you did follow the directives of my sergeant, who was let you leave the scene as we were ready to confront and assess what he had.
Did he cite any legal authority to make me leave the scene?
Objection, Your Honor. Relevance.
Sustained.
Relevance. John, I'm trying to understand the amount. Do you know? Okay. Never mind. How long were you on the scene approximately until I was arrested? Okay. Under 5 minutes?
I do not recall at the moment. I was looking report to refresh my memory.
Did you or your sergeant establish or discuss any probable cause to arrest me?
My sergeant gave us a directive to put you in the back of the patrol vehicle due to you obstructing our investigation. We were trying to assist your friend in getting medical attention. At that point, you were resisting. You put your hands onto the car, that patrol vehicle in the car, and you clamped your
Okay.
palms together.
So, but hold up a second.
No, you cannot stop him. You ask the question, he's going to get to answer it. So you don't stop him. Go ahead. Go ahead. Yes, you may.
So at that point, you were resisting. So then we got the directive to detain you. And after you assault on our sergeant gives another directive to place you in the back of the patrol vehicle for assault on a police officer. So I had multiple encounters with you putting your hands on. Yes.
Okay. Backing up to the point of which I was thrown up against the vehicle. You're saying that the crime or the violation that I was in was not stepping away. Is that correct?
You were obstructing the investigation, yes.
Is obstruction, is that a physical act?
Trying to object is a legal conclusion.
Sustained.
Is obstruction of justice, is that a verbal or a physical?
Sir. What are you asking? Because it seems to me that you seem to be asking this officer for a legal conclusion. And
Okay.
I'm not going to have him answer the question until you can clarify what your question is.
In your opinion, is it your opinion that I obstructed physically?